More stuff going on. So I hope that's true. I hope you guys are busier than last year. I hope so. So far sounds good. Do you know we're even open on Saturday? Don't abuse it, but we are open on Saturday, 10 to 2. You know what I've noticed when people call on Saturday? It's like happy hour. They've been enjoying themselves a little bit too much already on Saturday. So. I never knew realtors drank on Saturday, but they apparently do. Okay, why am I here today? I'm here to update you on the latest stuff, okay? I want you to know. Now, I'm being videotaped. Where'd the camera person go? I better not move, I'm right in. So, if you forget what I say today, this will be on the website, right?
YouTube, yes.
YouTube, too, right? When will it be on the website? Tomorrow? Today?
Today, yes.
Later today, you'll be able to see this. You can go back and look at it anytime. Maybe tomorrow if we're looking. All right. Okay. All right. So I want to update you on the latest laws and the latest forms, the new stuff you need to know. Okay? Let's start with various categories. First thing, disclosures. Anything new on disclosure? Well, have you noticed on the transfer disclosure statement on the first page, on the bottom right-hand corner, there's a new checkbox. What does it say? It says water conserving plumbing fixtures. So every time you sell a house now, the seller has to either check a box or not check the box, disclosing if the house has water conserving plumbing fixtures. It's interesting. In 2017, all of us have to upgrade our houses to have water conserving plumbing fixtures. You don't have to do it for 5 years. But starting now, you have to disclose whether you've already done it. Now, the seller, I know, when they fill out the TDS and they come to that place, maybe they're going to ask you, they're going to say, hey, realtor, what do I do here? Do I check the box or not? And you say, do I look like a plumber or something? You know, why are you asking me? No, don't say that. First, you ask them, what year was the house built? If the house is newer than 1994, you check the box. Because every house built since 94 already has water conserving plumbing fixtures. What if the house is older than 94? Well, ask the seller, I mean, did you do it, or did you upgrade already or not? They say, I don't know, I don't remember. Then tell them, don't check the box. You know what I mean? I mean, you don't have to upgrade for 5 years. You just have to disclose starting now whether you have upgraded. And if your house is newer than 94, it's automatically upgraded because the building code has required it since 94. Okay? Not a big deal. You don't have to go. You, the realtor, do not have to go try to figure it out for the seller whether they have water conserving plumbing fixtures. It's not your job to figure that out. And if they don't know, I would not just check the box. Now, some people have already asked me, what if I've upgraded one bathroom, but I didn't upgrade the other bathroom? Do I check the box or not? You know what I say? I say, either way, attach an explanation. Attach to the TDS a little statement saying, well, yeah, I upgraded one bedroom, but I didn't do the other one. You know what I mean? I mean, tell them the story. Tell them what the truth is. The other thing is, starting 2 years in 2014, if you need to get a permit to do anything on your property, let's say you want to do a renovation, it requires a permit. To get the permit to do anything, you will have to upgrade and put in the water conserving plumbing fixtures. You won't be able to get a permit for anything until you do that. When I say plumbing fixtures, I mean the faucets, the shower heads, and the toilets have to be upgraded. So every one of us has to upgrade by 2017. If we're going to do other renovations that require a permit, we're going to have to upgrade in 2014. But everybody selling today has to disclose whether you've done it or not. Okay? All right. Second thing on disclosure, carbon monoxide detectors. How many of you own a single family home? Raise your hand. How many of you, keep your hand up if you don't have a carbon monoxide detector? Let's look at all the criminals in the room. You're a criminal. You're supposed to have one and you don't have one. How dare you violate the law? But you know what's interesting? You were supposed to do it on July 1st last year. But it's not a point of sale retrofit. It's different than smoke detection. You know what the smoke detector law says? If I'm selling you my house, if I don't put in the smoke detector, before it closes, you can sue me for not putting in a smoke detector. But with the carbon monoxide detector, if I sell you the house without the carbon monoxide detector, you can't sue me. I mean, I have to tell you that I don't have one. I mean, there's a checkbox on the TDS, carbon monoxide device. So if I don't have one, I don't check it. I sell you the house. What am I telling you? I'm telling you, the buyer, I'm saying I'm a criminal. But if you buy my house, you become the criminal. You know what I'm saying? It's not a point of sale requirement. You're just supposed to do it. You're supposed to tell the buyer if you've done it. And then, I know in the real world, I wouldn't know what the buyer's going to do. If the buyer, when they see the TDS, and you don't check the carbon monoxide device box, they're probably going to say to the seller, aren't you supposed to put one of those in? And then the buyer says, I'm not going to close escrow until you put one in. Or maybe the lender will say, we're not going to fund the loan until you put one in, right? So other people may sort of make you do it. So you probably should do it anyway. But it's not a point of sale mandate. It was July 1st. So the next question is, you know, in smoke detectors, not only do you have to put it in, but you have to give the buyer a form that says, I am in compliance with the smoke detector law, right? And also the water heater certification. Did you know that that form is now on the TDS?
Mm-hmm. Yes.
So if you give a TDS, you don't need a separate smoke detector water heater form. But what if you're selling an REO property? They're exempt from the TDS. They're not exempt, though, from the smoke detector water heater form. So in those deals, you need a smoke detector water heater form. Well, then people call the hotline and say, well, where's the carbon monoxide detector form? And we tell you there is no carbon monoxide detector form because it's not a point of sale retrofit. But every day, like 10 or 15 realtors call us up. I can't find the carbon monoxide detector form. And we say, because there isn't one, you don't need one. Then the next day we get 10 more calls. We got tired of these calls. So in April, you're going to see on zip forms a carbon monoxide detector form. It is not mandatory. You do not need the form. Why do we do the form? Just to shut you up. We're tired of the question. All right? So smoke detector form is required, but it's on the TDS. If you're doing a transaction without a TDS, then you do need the separate smoke detector water heater form. Carbon monoxide detector, there's a form coming, but it's not required. It's just information about carbon monoxide if you want to give it to your clients. If it makes you feel good to give it to your clients, but it's not required. The water conserving plumbing fixtures, there's no form at all. You just disclose, checkbox, do you have it or not? Okay? That's the latest on disclosure. All right, now let's talk about the latest on short sales. Anybody ever do a short sale? Yeah, okay. One thing you know about a short sale, it's not short, right? It takes a long time. It shouldn't be called a short sale, right? Okay, all right. What do you need to know about a short sale? Okay, first of all, most important thing, every time you do a short sale, make sure you use this form called the Short Sale Information Advisory, SSIA. Give that to your client, make sure they sign that form, because that form explains things about deficiencies and taxes. If you don't give them that form, they could come back later and say, my realtor never told me this, my realtor never told me that. So always make your clients sign the Short Sale Information Advisory. So, what are a couple things you need to know? First of all, deficiency and taxes. Let me ask you this. Let's say you owe the bank $400,000, but the house is only worth $350,000, right? That's a short sale, right? You owe more than it's worth. So you get an offer for $350,000, accept the offer, you submit it to the bank. Hey bank, can we do a short sale at $350,000? And the lender says, okay, I approve the short sale for $350,000, even though you owe us $400,000. Escrow closes. Can the lender go after the seller for the extra $50,000?
No.
Not anymore. The law now says if the lender approves the short sale, whether it's a first, a second, owner-occupied, non-owner-occupied, refi, cash out, HELOC, If it's a loan secured by residential 1 to 4, so it's single family, duplex, triplex, or fourplex, if that's the property we're talking about, as soon as the lender approves the short sale, that's it. They can't get any more money from the seller. They can't even ask the seller politely, would you please give us some more money? No. You shouldn't even have asked me. I'm going to sue you for asking me. The law says they can't even request that you sell or give them any more money. The lender could, but the lender, of course, doesn't have to approve the short sale at all, right? They can always say, no, we're not going to approve it. You know what the lender can say? Well, we're not going to approve it unless somebody gives us some more money. Not the seller, but maybe the buyer wants to give us more money. Maybe the realtor wants to give us more money. You don't want that, right? Okay. Anyway, so that's point number 1. There are no deficiency judgments allowed when you do a short sale on residential 1 to 4 property in California. That's not true other places, by the way. If you're in Texas, you do a short sale, the lender will sue you for the extra money. If you're in Florida, they'll sue you for the extra money. If you're in Germany or France or Italy, they'll sue you for the extra money. Only in California do they not go after you for the extra money. All right, so that's good. But now the second thing, though, is the tax situation. Okay, so you owe the bank $400,000. The house is worth $350,000. You do a short sale at $350,000. You don't owe the bank any more money. You're done. But since you don't owe the bank the money, the IRS says, aha, you've had a debt forgiveness. You owed somebody $50,000 and now you don't owe them the money anymore. So they send a 1099 to the IRS and they send a 1099 to the seller. It says, you just had debt forgiveness of $50,000. So do you have to add that to your income on your income tax form? It depends. If it's your primary residence, you're doing the short sale, you do not have to report that $50,000 as income. Does the primary residence mean I have to live there now? It means you either live there now or you've lived there 2 of the last 5 years. Primary residence, you don't have to pay the tax. But guess what? That law expires at the end of this year, 2012. So if you close a short sale in 2012 on your primary residence, you don't owe any more money to the IRS or the seller. If you close a short sale next year, you don't owe the seller any, you don't owe the bank any more money, but you're going to have to pay income tax on the debt forgiveness. What am I telling you? This is the year to do the short sale. If you have any clients who are thinking, oh, maybe I'll sell my house this year, maybe I'll sell my house next year, tell them there's a tax incentive to sell the house this year. Because next year you're going to have to pay income tax on the short sale. There are 2 other ways, by the way, to avoid that tax. If you go to bankruptcy, you don't have to pay the tax, even if it's not your primary residence, even if it's next year. Or if you are legally insolvent prior to the short sale, you owe more than your assets, you don't have to pay the tax. You, the realtor, do not sit down with your clients and give them tax advice. You don't explain this to them. What do? You give them that form I just told you, and you know what you can do? You can download from the C.A.R. website, under the legal section, there's a Q&A called Tax Consequences of Short Sales. You can just download and give it to them. Say, here, read this. Talk to your accountant. Everyone with me?
Is there a movement now to extend that?
Yes.
To 2012?
Not just a movement. C.A.R. you have sponsored legislation to extend that tax break, federal law and state law, to beyond this year. But we don't know if that's going to get passed. Have you heard that there's some type of budget deficit in the government? Have you heard this? I heard this rumor there's a budget deficit. So they may not extend any tax breaks. So we don't know, right? One more thing. What if it's a purchase money loan, you don't have to pay the tax. If you refied a purchase money loan, you don't have to pay the tax. But if you refied a purchase money loan and took out extra money and used that extra money not to improve the house, but to buy a car or something, then you are going to be partially taxed on that income, even though it's your primary residence.
Next year?
This year and next year. In other words, you're not exempt if you're only exempt on purchase money or refinance of purchase money or home improvement loan, but just cash out to buy something else. I mean, this is complicated stuff. I don't even know all the details. There's a formula. You got to talk to their accountant. But still, the bottom line, what I said is true. You have a tax incentive to do the short sale this year, okay? On your primary residence. What if it's not your primary residence? Well, you're going to have to pay the tax unless you declare bankruptcy or you're legally insolvent. Anybody using short sale negotiators? That's okay, but remember they have to be licensed. They cannot get paid in advance, and they can't get paid outside of escrow. This is what they're cracking down on now. Be careful using short sale negotiators. Well, who's cracking down? The DRE, the police, the FBI. Everybody's cracking down on you. You got to be more careful now. You can't violate the rules anymore. You know, the DRE is tougher than it used to be. Why are they tougher? Well, first of all, there's a new law that says, there are all sorts of new laws about the powers of the DRE, Department of Real Estate. Do you know that if you do something wrong and the DRE investigates you and they find out that you're guilty, they can send you a bill for the cost of investigating you. They put you on a restricted license, they can bill you for the cost of monitoring you on the restricted license. Here's the latest thing from the DRE. It used to be the DRE could not punish you until they did a formal investigation, and first they had to inform you that they were investigating you, right? And then you have a whole formal investigation, then you have a hearing. There's a new law that says for minor violations, the DRE doesn't even have to tell you that they're investigating you. They can just call you up on the phone one day. Guess what? We've been investigating you. We think you're guilty. You got to pay a fine of $2,000. You didn't even know you were being investigated. All of a sudden you got to pay a $2,000 fine. Well, you could say, no, I don't want to pay the fine. I want to get an investigation. I want to have a hearing. So they say, okay, but you know what? If you go to the hearing and then you lose, you get disciplined, and that's on your permanent record. So for the rest of your life, if someone goes to the DRE website and they pull up your name, that discipline, that punishment will be there. But if you just pay the fine, just shut up and pay the fine. That doesn't go on your record. That's not considered discipline. Doesn't that sound like extortion? Pay and we don't tell anybody. Make us prosecute you, it's going to go on your record. But you know, the police already do that, don't they? Don't you watch TV cop shows? Law and Order, they say, if you plead guilty, you get 6 months. If you make us prosecute, you go to trial, we're going to go for 10 years, right? Police already do that. Now the DRE does that, all right? So be careful. More things about the DRE. Well, first of all, how many of you in this room have a broker's license? Okay. If you're a broker, you can hire agents, right? But if you hire agents, you have to supervise the agents, right? What happens if you hire an agent and you don't supervise them properly? The DRE can punish you. Well, some brokers hire a manager, right, to supervise the agents. That's okay. But there's a new law that says, this is effective in July, not now. If you're a broker and you hire a manager, you have to have a written contract with the manager. All you brokers out there who have managers, starting July, you have to have a written contract. We're going to have a new form on Zip Forms called the Broker Manager Contract. It'll be available in April. And then, you ready for this? You have to register the manager with the DRE. So you got to tell the DRE if you have any managers. You know what this means? That means now the manager is responsible to the DRE for supervising. So that's not so good for managers, is it? I think if I were a manager on July 1st, I'd do one of two things. I'd either quit or demand a raise, right? Because I have more liability now. broker, I want some more money. But the point is you have no choice. If you're a broker and you have a manager, you must have a written contract with the manager. And number two, you must register the name of the manager with the DRE. They have a form for this too. By the way, as I said, I'm being taped. You can go look at this again, which is why I don't really have handouts for you. Plus, but I'll tell you a couple things. In case any of you are interested, so it's on the tape too. The law about the water conserving plumbing fixtures was Civil Code 1102.6. The law on the managers, that you have to have a manager, is Business and Professions Code 10164. And the fact that the DRE can issue a citation without telling you is Business and Professions Code 10080.9. Also, if you go to our website, you go to C.A.R.org, right? On the home page, one of the choices is legal. You press legal, now you're on the first page of the legal section. One of the items on the very first page, it says 2012 new laws. You can just click that and everything I'm saying is right there. Or another thing you can do, another thing on the first page of the legal website is Risk Management Report by me. And I have a new one up there, I think tomorrow, which will talk about all this stuff that I'm talking about today, if you want to see that too. Plus I'm on tape. I'm on YouTube, right? I'm all over the place. So if you just Google me, you'll find me on YouTube. This Board of Realtors is very nice. They told me we're going to tape you. They even asked me to sign a form that said it's okay to tape me. You know what a lot of realtors do? A lot of realtors go to my meetings, they tape me without even telling me. Then all of a sudden, I Google myself, I go on YouTube, and there I am talking. Nobody even told me they're taping me. I'm talking just like this. So if you ever want to know what I'm talking about, just Google me. There are YouTube videos just like this. At least your association is nice enough to ask me, tell me, ask me to sign a release, and I did all that, so it's good. All right, okay. A couple more things with the DRE that you should know about. So number one, managers have to register. Number two, you can be investigated and punished on minor violations without being told.
Can I ask you a question?
Yeah, don't wait till the end. You can ask questions anytime.
You say the owner hired the manager.
Broker hires a manager.
Broker hired the manager.
Right.
But is it for the new company or existing?
If you already have a manager. Yeah, existing companies. If you already have manager.
Like this company already opened like 30 years.
Yeah, you had a manager for 30 years. You got to register the manager now. Now, when I say manager, I do not mean just a transaction coordinator. I don't mean escrow coordinator, just make sure the file is complete, you know. I mean a manager who actually supervises agents and has the authority to tell the agents, don't do that, do this, do that. That's a manager, not just a transaction coordinator. Not office manager just in charge of the staff. Yes?
Does the manager need to be licensed?
Very good question. Yes, the manager needs to either have a broker's license or a salesperson's license with at least 2 years experience as a salesperson. They cannot be on a restricted license, and they can never have had a revoked license. By the way, what's the punishment the DRE can do? They can revoke your license, suspend your license, put you on probation, restricted license. They can fine you, or they can reprimand you. Up until now, to do any of these things, the DRE had to do a formal investigation. They still would have to do a formal investigation to revoke your license, suspend your license, probation or restricted license. But now to fine you up to $2,500, they don't need the big investigation. They can just do the sort of informal investigation. Okay? Let me ask you something else. I'm sorry, yeah.
I have been brokered on my company more than 10 years.
Yeah.
And a year ago, I got DRE sent me a officer license and officer license and fee, like $800. So, did you know about that?
A fee for, you have a corporate office?
Yes.
I mean, I'm not familiar with the fees. I mean, I can check it out for you.
I'm by myself.
Yeah, I don't know the DRE fees.
So I got the
I'll check it out.
license.
If you want to call up, I don't know off the top of my head the answer.
Came from Nigeria.
Yeah, maybe. I don't know. You'd have to show it to me or something like that. Off the top of my head, I don't know. By the way, do you know that DRE is different than the other parts of the government? DRE is self-supporting. Your taxes do not support the DRE. Your license fees support the DRE. So have you heard that they're talking about, Governor Brown was talking about taking the DRE so it's no longer going to be a department, and maybe it will be a bureau under the Department of Consumer Affairs.
Right.
I think they're trying to steal the DRE's money.
Yeah.
I think that's what's going on.
Now you're on.
And they're talking about taking loan brokers out of the DRE
Oh.
and putting them over like Department of Banking or something like that. So we'll see. None of that has happened yet. Let me ask you something else. If you commit a crime not related to real estate, can the DRE take away your license for committing a crime? It depends on what crime. If you kill somebody, yes. Even if you don't kill your own client, you kill somebody anyway, you will lose your license. If you commit fraud in another part of life and you get convicted, you can lose your real estate license. But not all crimes result in, $25 fine. Okay, anyway, let's say, to me exactly, what about a DUI? So you get convicted of DUI. If you're driving your client around, that's a problem. But you just, it's got nothing to do with your client. You just DUI. Can the DRE take away your license because you committed a DUI?
Yes.
It depends. Felony DUI, probably. Misdemeanor DUI, it depends on the circumstances, how many times, blah, blah, blah. Okay, that's all, nothing new there. But here's what's new. New law says, real estate licensee, if you get arrested for felony DUI or any other felony, you have to self-report to the DRE within 30 days. In other words, you're not even guilty yet. You may never be guilty. You may be acquitted. The fact that you've been arrested, you have to disclose to the DRE. If you don't do it, if they find out later that you didn't tell them that you were arrested, they can take away your license just for not telling them. Or if you're convicted of any misdemeanor, so arrested for a felony or convicted of a misdemeanor, you must self-report to the DRE within 30 days. See, sometimes they don't figure it out for years. All of a sudden, 4 years later, they do a background check when they renew your license. Oh, we got arrested 3 years ago. Well, if that ever happens now, you're going to lose your license because you didn't tell them you were arrested. Or if you get sanctioned by any licensing entity anywhere. Let's say you have a contractor's license, and the California Contractors Licensing Board says you did something wrong and they sanction your contractor's license. You have to report that to the DRE within 30 days. Or even you have a real estate license in Texas or something, and the Texas Department of Real Estate says you did a bad thing. You got to tell the California DRE that you did something bad in Texas. And if you don't tell them, they can take away your California license.
What is the punishment that the DRE hands you if you self-report within the 30 days on a arrested misdemeanor?
Well, they can't do any, in other words, if you do the right thing and report it, at that point they can't do anything to you because you haven't been convicted. And even if you do get convicted, it's not automatic. Felony, it's pretty automatic. But the problem is if you don't tell them. But remember, you don't have to report an arrest for a misdemeanor. You got to report a conviction for a misdemeanor and an arrest for a felony. So if you get arrested with a misdemeanor, and we're not talking about traffic tickets now. You don't have to tell the DRE about all your traffic tickets. Because I know you have a lot of those, right? So you don't have to disclose this, all right? Okay. A couple more things from the Department of Real Estate you should know about. All of you guys who raised your hand said you're a broker. You're allowed to do your own escrows, right? You know that?
Yes.
You can't do other people's escrows, but with a broker's license, you can actually do the escrow for your own transactions. New law says, starting in July, if you do 5 or more of your own escrows in a calendar year, you must file an annual report with the DRE as a broker escrow. And that's Business and Professions Code 10141.6. All right, one more thing, two more things from the DRE. First of all, I just told you if you get arrested for a felony, you get convicted, you lose your license. But the law used to say you don't lose your license until your criminal appeal is over. So sometimes what would happen is real estate licensee gets arrested and convicted of a felony and they go to jail and they're sitting there in San Quentin. But their appeal is still going on. So they still have their license. So they're still doing real estate out of San Quentin. Makes the DRE look really bad. There's a new law that says as soon as you hit prison, you lose your license. Forget this appeal thing. You lose license as soon as you hit prison. All right, I got one bit of good news from the DRE, and that is they've made it official. It is legal for all of you to use your nickname. I know you were all doing this anyway. But up until this regulation 2731, you were supposed to put on all of your marketing materials your full name as it appears on your license. How many of you already weren't doing that? You can admit it. I'm your lawyer. I'm not going to turn you in. You've all been doing your whole name on your license. Well, you don't have to anymore. If your name is James, you can shorten it to Jim. If your name has 15 letters, you can shorten it to 3. You don't have to have your real name on your... You have to have your DRE license number, and you have to have your real last name. With your first name, you can call yourself whatever you want. You know? So that's good. All right. Let me talk about... yes?
What about own child support? Is that still?
What about child support?
I mean, somebody own child
Right.
support can
They lose your license for that? Oh, yeah. Yeah, that's very serious.
Oh, yeah.
That's like more serious than a crime. That's like worse than murder. You will really lose your license if you don't pay child support. Killing, it depends, but no. Child support is serious. All right. Let's talk about, so that's the latest on disclosures. I told you that. The latest on the taxing of short sales. You need to know that. The latest on the Department of Real Estate. Yeah.
If a client lives here but short sold in Nevada, what would be his best advice to give him?
So in other words, the property's in Nevada?
Yes, but he lives here and doesn't tax it.
Unfortunately, it doesn't really matter where he is if the property's in Nevada. I'm not really an expert in Nevada law, but I don't think pretty sure they don't have the same California anti-deficiency laws. So, yeah, I mean, he's probably going to have to, the lender could go after them, theoretically.
So what should I come to counsel? Someone over there?
Yeah.
A lawyer over there?
Yeah, that's all you can do.
Okay, thank
Yeah.
you.
Okay, next topic. Let's talk about rental property. A lot of you are landlords, a lot of you might be property managers. Did you know, by the way, if you have a property here in the San Gabriel Valley, but the owner of the property lives in Nevada, and you collect the rent here, and you mail it to them in Nevada, you have to take a certain amount of money out before you send it to them. Tax withholding. And you got to send it to the Franchise Tax Board. We have a Q&A on this, on tax withholding on rental properties, 7%. Well, what if your client lives in China, but the property's here? You're collecting the money here and you're mailing it to China. You got to withhold even more than 7%. What if they have a 20%? You're right. What if they have a bank account here and you put it in their bank here? Same thing.
What? Same thing?
Yeah. Now you can apply for an exemption, but their position, the Franchise Tax Board told us, we don't care if you're putting it in a bank account here. You're the one putting the money in for them, so you should withhold it. It doesn't really make sense if it's not being mailed to China, but that's what they said. You can call the Franchise Tax Board, and I've heard they grant exemptions, but that's what they're saying.
When did that go in?
Not that recently. I mean, they've started enforcing it recently, but I think it's been on the books for a while. Yeah.
I have a Bangkok client. I keep the money in my trust account because we can't find him.
Cool, a client you can't find. Okay. Well, you're doing the right thing. Put it in your trust account.
We just keep it in the
Yeah,
trust account.
right.
We don't put it in his bank account. The bank won't accept it anymore,
Good.
because they can't find it.
Right. Yeah. Just keep doing what you're doing.
Give it to the state when I,
Eventually, so this person doesn't have any heirs either. I mean, they just don't
well,
know
he's
where it
got two heirs, but we can't find anybody.
is. Just keep doing what you're doing. That's all you can do. That's all you can do. Yeah.
Question.
I'm 105 and I'm still doing it.
If the owner is a U.S. citizen, live overseas,
Right.
they file income tax every year. Are you still
Here.
recording?
So where's their official residence?
They are U.S. citizen.
I know, but where's their residence?
They live in Bangkok.
Well, then you got to do the withholding.
They file tax every year.
Yeah, that doesn't matter. You still got to do the withholding. Okay. Yeah.
How about a property owner is a partnership with one is citizen in here, one's on 51% in mainland China. So what's the percentage?
In all seriousness, call the franchise tax board because they are really good on this one. They've been very helpful. You call them up, they'll give you a good answer.
Yeah, we want the money different.
I'm sorry?
Would it apply to out-of-state LLC?
Yeah, I don't think they make an exception for that. Yeah. Now, what if the tenant mails the check directly to the out-of-state person? Well, that's no problem. Of course, then why do they need a property manager if they're going to mail it directly? You know what I'm saying? But if you're involved in the process, you're collecting the rent, they say that you have to do the withholding. It's possible to get an exemption, but just call the franchise tax board and they'll help you, but you still got to do it. Okay? All right. Rental properties. Let me ask you something. Can a landlord prohibit smoking?
Yes.
Why are you so sure? Because it makes sense, right? And for years, people have been asking me, can a landlord prohibit smoking? And I say yes. But I never really had a reason to say yes, other than I thought that it made sense. Well, now there's finally a new law. You know what it says? You can prohibit smoking. So we were right all along, right? But the law says that if a landlord wants to prohibit smoking, you have to put it in the rental agreement. So let's say you have a rental agreement with somebody, it doesn't say anything about smoking. And then one day you say to the tenant, oh, by the way, the rule here is no smoking. The tenant can say, that's got to be in the rental agreement. I can still smoke. So you'd have to send them a 30-day notice to change the terms of the tenancy and say, this is your official 30-day notice that 30 days from now you can't smoke on this property. If you use a C.A.R. rental agreement, our rental agreement already says no smoking. But some people don't use the C.A.R. lease. You got to make sure it's in there, okay? Now the C.A.R. lease form says no smoking of any substance. So what if the tenant comes to you and says, wait a second, I know I can't smoke tobacco because that's bad for you, but there's something else I want to smoke that's actually good for me. And the reason I say it's good for me is because I have a prescription. My doctor told me to smoke the marijuana. So since my doctor told me to do it, of course, you, the landlord, can't stop me, right? Wrong. Even if they have a prescription, landlord can prohibit smoking anything, including medical marijuana with a prescription. Because of federal law, you're right.
What about this new device you see on television? Where it's not even smoke. You know,
Smokeless or something? Or?
Yeah.
I don't really not familiar with it. It's still,
I mean, to me, it's still
smoking though, right? It's still, I mean, I don't know, I'm not an expert on that. It doesn't sound, it sounds like it's probably a problem. It sounds like you could still prohibit that. You know, when I go to Humboldt County, they're very concerned about this. You know, has anyone ever been to Humboldt County? Every realtor smokes marijuana there. Just yes, and out. You can prohibit smoking inside or out. Let me ask you this, can a homeowner association prohibit smoking?
Yes.
Only in the common area. Homeowner association cannot prohibit smoking in the unit. But did you hear what the city of Pasadena did?
Yes.
They passed a law that says I think it's effective next year, right? It says you cannot smoke in any rental property in Pasadena. Multi-unit, yeah, including condos. Even if the landlord doesn't care. So the landlord, tenant says, can I smoke? Sure, smoke all you want. Doesn't matter, the landlord wants, it's okay. The city is saying you can't smoke. The good news is the law says that it's not the landlord's responsibility to enforce this. So you know what's going to happen next year in Pasadena if you're in a rental property? 2 in the morning, the police are going to knock on the door to make sure you're not smoking. They're going to have special no smoking police in Pasadena. I don't know how they're going to enforce this law, but it's a law. Okay? Yeah.
Also in South Pasadena too, or just Pasadena?
All I've heard so far is the city of Pasadena. You know, the city of Alameda up north also.
Yeah, just ask, you are lease the house, the tenant move inside. How can you don't know when you rent you don't know?
How do you know? You're right.
You don't know.
Just knock on the door in the middle of the night to see if they're smoking.
When you are neighbor, you are owner, and the tenant staying in your neighbor, he's smoking in your garage, in your garden. You have something, he smoke. You heard the dog, he's don't smoke. You can't read it.
It's hard to prove it, but if you could actually prove that they're smoking, you can evict them.
Yeah.
All right? Okay. A couple more things on rental properties that you should know about. We're in election year, as you know, so there's a law that says the landlord cannot prohibit the tenant from putting up a sign, political sign. The tenant wants to put up a sign on the door, they want to put up a sign on the window, vote for this, vote for this. Landlord cannot prohibit that. Okay? They can limit you, though, to 90 days prior to the election to 15 days after the election. Okay?
And the size?
And the size?
And the size can be limited to 6 square feet. Okay? All right. You can say no bigger than 6 square feet. Let's see.
How about real estate signs? They can limit?
Oh, yeah, they can limit real estate signs, unfortunately. They can say no real estate signs. Political signs are one thing, real estate signs are something else. Discrimination. You know that California has the strictest anti-discrimination laws in the country, probably the world. In California, you can't discriminate based on someone's race, their religion, the color of their skin, the country of their birth, their age, their gender, their marital status, their family status, whether they have children, their sexual orientation, or their source of income. You can't discriminate against lawyers, unfortunately. Source of income, right? There's a new category this year. You can't discriminate based on someone's gender identity.
What does that mean?
Here's what that means. You can't discriminate against someone because their appearance or behavior does not correspond to the typical appearance or behavior of someone with their gender characteristics. Does anybody not know what I'm talking about? No, it's now officially illegal.
Wow.
Okay? Pardon?
Can we wonder? Can we wonder?
Yeah, you can, but by the way, can you discriminate based on someone's appearance? Can you say, you can't live here if your hair is too long? Why not? I didn't mention that. I said race, religion, blah, blah, blah. I didn't say anything about hair length.
Are you wearing your pants too low?
I mean, the thing is, you could have an appearance-based, but it better be consistent. You better not have any exceptions. Everyone who lives there must meet your appearance. And I'm sort of kidding when I say this, because if you do that, they're going to say, oh no, it's really based on my race, religion, age, skin. They're probably going to complain and try to say it was something else. The safest thing to do when you're a landlord and you're screening tenants is you screen them based on objective criteria. Credit score, income level, time they've been on their current job, criminal record, no bankruptcies, no unlawful detainers, factual information. Then, you know, don't ever reject someone on some other reason. Always be able to give them a reason. Well, your credit score didn't meet my criteria. But that means all of the other tenants you have to have credit scores that good too. You can't just pick and choose, right? You have to have standards and follow them. What if you get three applicants and they all meet your standard. They all have high credit score, high everything. Well, now I'm just going to pick the one I want, right? I pick the one I like best. Well, the other two might sue you. They're going to say, I met the criteria, why'd you pick him? And you're going to say, because you're a loser, that's why. But that's not objective enough. They're going to say, oh, it's probably based on my religion. It's probably based on my age. It's probably based on the fact that I have children. The only way to guarantee that you will not get in trouble is if you take the first applicant who meets your objective criteria. And who can complain then? You got to be very careful as a landlord not to discriminate because they will sue you. Okay? All right, that's the latest on discrimination. That's the latest on rentals. Yes.
What about the like sexual molester that have a record?
You can always discriminate based on someone's criminal record. You do not have to rent to anyone with a criminal record if you don't want to. Any criminal record. That's objective. That's factual. But if you rent to one criminal, you got to rent to the other criminals. Well, you can pick and choose your crimes. I will rent to thieves. I will not rent to child molesters. That's fair as long as you're consistent. You know what I'm saying? You got to be consistent. Okay? All right. Let's talk about forms for a second. Okay, so yes, I'm sorry. Very good question. Is it legal to say no pets? Yes. But what if the tenant says, I have a comfort animal, or I have a seeing eye dog, or I have a hearing dog? You have to make an exception to your no pet policy if someone has a disability. By the way, you do not have to make an exception to your no marijuana policy, even if they have a disability. But it's different for pets. Can a homeowner association prohibit pets? No. They have to allow you to have at least one dog or one cat. They can restrict how many, they can restrict how big, but they cannot say no pets. They cannot say no dogs. They can have a reasonable restriction. Okay? Yeah?
When a landlord declines Section 8 tenant.
Yes. What I mean by that, a landlord doesn't have to be a Section 8 landlord. Let's say you already are a Section 8 landlord and you're tired of being a Section 8 landlord. You can give all your tenants a 90-day notice, say, in 90 days I will no longer be a Section 8 landlord, you're going to have to pay the entire rent. If they can come up with the money, you got to let them stay. But you do never have to be a Section 8 landlord, but you got to give 90-day notice to get out of it. Now, if you are a Section 8 landlord, you can't refuse someone because they're Section 8, you have some Section 8, some, I mean, then you have to be consistent, yeah.
Aren't you supposed to at least wait for that 2-year lease or what?
Oh yeah, you got to wait till the lease is over as well, yes. You always have to, if you're on a lease with somebody, you can't do anything till the lease is over, right?
Are there different restrictions if it's your own property and you're living on the property? There's like a guest house there that you...
Yeah, there's an exception, if you're talking about, there's an exception to the discrimination laws for property that you're living on. You know what I'm saying? Not a guest house, though. You can't discriminate on a guest house. But if you're renting out a room in your house, right? You know, in other words, I want to rent out the spare bedroom. You can discriminate all you want. You say, I'm looking for a particular race, religion, age. I want someone who's exactly 37 years old, with no kids, red hair. You can be as discriminatory as you want to a bedroom in your house. But a guest house, no. A guest house is just like any other rental property. You can't discriminate. Okay? All right. Let's talk about forms for a second. Okay. I'm going to talk about a couple more new laws in a second. But forms that you need to know. C.A.R. does new forms twice a year. What months do we do new forms?
April.
Very good. April, November. So first I'll tell you what happened in November. Then I'll tell you what's going to happen in April. So what happened in November? First of all, the good news is nothing big. No changes to the purchase contract, no changes. I already told you one thing, that TDS has a new box on water conserving plumbing fixtures. That's no big deal, right? First, let me tell you about 4 new forms. They're all one page and none of them are a big deal. There's one form called the ABAA. Additional Broker or agent acknowledgement. When would you use this form? Well, have you ever noticed on the purchase contract, on the last page, you put your name, right? You represent the buyer or the seller. You put your name on the contract. You know what the purpose of putting your name on the contract is? You're telling the other agent on the other side that you're the agent for your client, and if they want to deliver anything to you, you will accept delivery of documents on behalf of your client. But what if you're going away on vacation for 3 weeks? You're going to China, you're going to Thailand, you're going to Africa. You're going to be out of touch for 3 weeks. You want to tell the other agent, I'll be gone for 3 weeks. You can send the documents to somebody else. So you give them the form that makes it official that says this is the additional agent. Or maybe you put your broker's name. But you have to make it official in writing. Because when you put your name on the contract, you are saying to the other side, I'm the only person you can deliver. Don't deliver to my assistant, my partner. If you want to deliver something to my client, you have to deliver it to me at the email address I put on the form. But if you're not going to be available, you got to tell them you're not available. Or maybe right at the beginning of the deal, you have a partner. Some agents work together as a team, right? And you want to tell the other side, either one, if you want to deliver something, deliver it to her or me, either one's fine, right? But on the purchase contract, there's only room for one name. So you can use this additional broker or agent form right at the beginning of the transaction to inform the other agent that there are two of you on this deal. You put one name on the purchase contract, you put the other name on this other form, the ABAA form, okay? I call it the ABBA form. Remember that group called ABBA?
Yeah.
Okay, what was their big song? Come on. Dancing Queen. Dancing Queen is correct. Some of you don't know what the hell we're talking about, right? Dancing Queen ABBA. Google
You guys
ABBA.
eliminated the listing income unit.
The what form?
Residential income unit listing form.
A listing form for income units?
Yeah.
Really? I didn't know.
I couldn't find them there.
No, it should be there.
I couldn't find them. Now
Is anyone else having trouble finding the listing form for income?
They changed it to commercial.
Yeah, it's commercial.
Oh, they changed the name, yeah. Now it's called the commercial. Do you not like the name change?
No.
You're protesting against the name change. Okay, I'll let the forms committee know. Okay, yes?
If you're in the middle of a transaction
Yeah,
and you want to go on vacation,
Yeah.
you use the ABBA form.
yeah,
Okay.
right.
Because you said at the initial.
I'm saying you could also do it right at the beginning if you know right from the beginning that there's more than one of you on this deal. Okay?
Use it anytime.
Use it anytime you want. Second form is a form called very simple form, it's called the Extension of Lease, EL. Very simple form. You want someone on a lease, you want to extend the lease, you don't want to do it. In other words, you don't want to turn them into a month-to-month, you want to extend the lease. We have a form, extension of lease. In other words, you don't have to fill out a brand new lease. Just make them sign this form. We're extending the existing lease on the same term. You can even change the rental amount on this form. You can say we're extending the lease, but we're changing the rent. Okay? Very simple. That's two new forms. Third new form. It's a form called the Water Heater Statement of Compliance. Now, I was telling you before that if you're doing an REO sale, the seller has to give the buyer the smoke detector water heater statement of compliance, because on an REO sale, there's no TDS. And the TDS, if you don't have the TDS, you need a separate smoke detector water heater form. But if you're selling a trust or a probate or a bankruptcy, there's no TDS, but they're also exempt from the smoke detector compliance form, but they're not exempt from the water heater compliance form. So there's a separate water heater compliance form. Now, if I just gave you a headache, and you don't want to remember that, just give everybody the smoke detector water heater form and you're okay. Some of you like the real technical details. So the technical details is on a probate or a bankruptcy or a trust sale, TDS not required, smoke detector water heater form not required, just a water heater form. So there's a new water heater statement of compliance. One thing you should remember, by the way, is nobody is exempt from putting in the smoke detectors and strapping the water heater. Some people are exempt from the compliance form, like on a trust, bankruptcy, but no one is exempt from putting them in. Are any of you doing REO sales? They think they're exempt from everything. Have you noticed that? Yeah. They're not. Just because they say they are doesn't mean they are. They're not exempt from agency, natural hazard disclosure. They're not exempt from smoke detector water heater. They're not exempt from carbon monoxide. You know what they're exempt from? The TDS, the booklets, and the SSD form.
City compliance.
But they're not exempt from city compliance or code section or anything like that. But REOs do all sorts of funny things. Like they say, here's the addendum. We're not going to sign it, but you sign it. And then open escrow. So it's not even a contract. Or they say, if you don't close escrow on time, you got to pay a per diem penalty of $100 a day. California courts won't enforce those, by the way. Or they say, if you don't remove your contingencies by the deadline, the contingencies are removed automatically. Have you ever seen that?
Yeah.
That's legal. So you got to be careful. If you're doing an REO sale, you got to tell the buyer, if you don't cancel the deal by the deadline, your contingencies are automatically removed and your deposit is now at risk. Whereas on a normal sale, your deposit is protected until you actually sign the contingency removal form. Okay? Anyway, let me get back to forms. So, first, I'm sorry, yeah.
Getting back to the probate or REO, what if the property is really being sold as land value because the structure is not, I mean, it's there, but it's not livable?
Yeah, unfortunately, you still got to deal with it like a resident. Even though it's not livable structure, you got to deal with it as a improved property.
So does that mean the water heater that isn't there has to be scrapped?
Well, you can't strap something that's not there. So you don't have to put in a water heater, so you can strap it. Right. You don't, definitely don't. By the way, a tankless water heater, you don't have to strap that either. Okay, all right. So we got the ABBA form. For those of you who don't remember ABBA, you have the extension of lease, you have the water heater statement of compliance. The fourth new form that came out in November is a form called the OVS, Optional Verification of Electronic Signature. Let me ask a question. How many of you have ever done a deal with e-signatures? Okay, not too many. Any of you, if you do try to do a deal with e-signatures, sometimes you come across the bank, we won't accept it, right?
Yeah.
B of A, we won't accept e-signatures. This form does not help you for that. This form helps you, though, if you have an e-signature and the title company or the escrow company say, well, it's not that we don't accept e-signatures, but how do I know that that's your client's e-signature? Well, this form would be signed with a wet signature by your client, and you give it to the escrow company. See, they said that that's their e-signature. So then they'll accept all the e-signature on all the other documents. But if the bank won't take it, you're out of luck anyway. You can't do e-signature. Okay? So that's the four new forms. Yes?
Gov, about the touch sign C.A.R. just launched, what about that? They sign on the iPad. Would it be considered as an e-signature?
That's a legal, perfectly good signature.
So the bank should...
But some banks just won't, as a policy, won't accept any e-signature, including that. They don't have to yet. We're trying to make it so you have to accept it, but at this point, they don't have to. Okay? Forms coming out in April. I already told you two forms. One form, the broker-manager contract that you have to have if you have a manager. Second form I told you was the unnecessary carbon monoxide detector form. Remember that? You will get the unnecessary, non-mandatory carbon monoxide detector form in April. Third form coming out in April is going to be called the parking and storage form. Why do you need that? Well, buyer buys condo, right? Then they close escrow and then they move in on moving day. And on moving day they find out their SUV doesn't fit in the parking space designated for them. What do they do now? They sue their realtor. You should have investigated my parking space before I bought the property. Now this will never happen to you because you're going to give them the parking form which tells the buyer it's your responsibility to verify the parking space is okay before you buy the stupid condo. Okay? So, you see, all of our forms are designed to protect you. Usually a realtor gets sued for something, and then we come up with a form so none of the rest of you will get sued for it. Seriously, that's totally the way it works, okay? All right. So those are the three new forms coming in April. There may be more. There's only 3. But there probably will be more. Between now and April, the Forms Committee may have more forms, but so far, just the 3, okay? So I told you the 4 that came out in November, the 3 that are coming in April. Now let me tell you a couple more forms that have been changed, okay? By the way, all of you in this room are either an agent or a broker, maybe some affiliates, I don't know, but mainly you're brokers or agents. If you're an agent, you're working for a broker, you must sign a contract with the broker, right? It's called now C.A.R. has a version of this form called the Independent Contractor Agreement. You brokers out there, you don't have to use our form. You can have your own form, Independent Contract Agreement with the agents. But there was a case last year that says you cannot have an arbitration clause in the broker-agent contract. So we had to take the arbitration clause out of our independent contractor agreement. Now some of you agents may already have been working for the same office for a few years and you're still working under the old independent contractor agreement that has the arbitration clause. I'm telling you right now, the arbitration part is unenforceable. So even though it's in there on the old one, if you do a new one, it's not there. But just because it says on your form, broker and agent have to resolve all disputes in arbitration, it's simply not enforceable. So all of you agents, you can just go ahead and sue your broker. Forget arbitration, sue. Okay, that's all. All right. Okay. So are there any other forms that changed? Okay, well, so that form took out the arbitration clause. The TDS has a new paragraph, new checkbox for the water conserving plumbing fixtures. Now there's a slight change to the homeowner association request form. If you list a condo, right, you know you're supposed to ask the homeowner association to give the buyer all the governing documents, right? Well, we have a form called Form HOA, which you're supposed to give to the association to tell them what forms to give to the buyer. That form has been updated. That form is now a mandatory form. The association is required to use that form as a cover sheet when they provide the documents. So just be aware of that. So there's a nice form. So if I were you listing a condo, I would download Form HOA, give it to my escrow officer and say, escrow officer, please use this form. Give this to the HOA and tell the HOA this is mandatory now. They have to do this. Okay? All right. 2 more things. HOAs can no longer charge an arbitrarily high fee for this service. You know, some HOAs, you say, could you deliver the documents to the buyer and transfer ownership? And the HOA, sure, we're going to charge you $1,000. New law says they can only charge you their actual out-of-pocket cost. Well, how much does it really cost to Xerox a bunch of documents, put it in an envelope, and mail it to the buyer? I mean, you add up the Kinko's bill and the paper bill and the UPS bill or the postage stamps and the time spent by the underpaid hourly employee who does this. I mean, how much can that possibly be? A couple $100? $100? So if the HOA tries to impose a document transfer fee of some outrageous number, you tell them you're breaking the law here. You have to prove to me that it cost you that much to do it. That's a good law it should save sellers money when selling condos, because you know the seller pays that fee. So they should basically say to their own association, you can't charge that fee. Okay? Yeah?
Can they charge you if they email the documents to the escrow?
If they email it, they can charge you, but how much would that be? I mean, you know, what's the actual cost of sending an email? It should be even less. They don't have to pay for the Xeroxing anymore. It should be even cheaper if they're going to do it. In other words, you're right, they're allowed to do it electronically. They don't have to print it out and physically deliver it. They can email. They can put it on a website. And that should be even cheaper.
Are they banned from using a third-party company?
No, that's the whole point. When they use a third-party company, the third party cannot charge more than the actual cost. See, that's the real problem. It's these third-party companies that have been charging these big money. Well, now, even if you use a third-party management company to provide the documents, they cannot charge more than their actual cost. Yeah.
Can the seller use the document they received when they bought it to give to the new buyer?
Can the seller save money by, when they bought it 3 years ago, they received the document, they just want to give the same one to the buyer. The problem is, there's no guarantee that those are still up to date.
With the update, with the changes.
They gotta, I mean, it's the seller's responsibility to make sure the buyer gets the updated version. It's always safer to have the HOA do it. And since they can't charge very much anymore, I think it's still worth it to pay that fee. Okay? By the way, there's another new law with HOAs that says, let's say you're buying a condo, right? And before you buy it, you read the governing documents. And they talk about the pet policy, the smoking policy, the using the swimming pool policy. There are all sorts of rules, right? So you read the rules, you say, okay, I can live with this, and you buy it. Then you move into your condo, and 2 months later, the board of directors changes the rules. All of a sudden, they change the pet policy, they change the smoking policy, and even though it was one way when you bought it, they changed the rules, you have to adapt to the new rules. I mean, that's the risk you run when you buy into a common interest development. But there's a new law that says there's one rule that if it changes, you're grandfathered in and you can still go under the old rule, and that is restrictions on leasing the property. So in other words, let's say you buy a condo today. Some condos have rules, right? They say anytime the property is more than 20% non-owner occupied or something like that, you can't rent out your unit, right? You have to live there. So if it has a rule like that, you have to follow it. But let's say when you buy the condo, there's no restriction. And then after you move in, they pass a rule that says if we have more than 30% non-owner occupied, you can't rent out your unit without board of directors approval. You who bought it before they put in the rule, you can continue to rent your unit forever. They can never stop you from renting out your unit. If you bought it with the understanding that you could rent it, you can always rent it.
The length of time you can rent it? Like when I first bought mine,
right,
we could rent it for the weekend.
Right.
Now they're saying you can't rent less than 7 days.
Did they pass that rule prior to January 1st?
Just January 1st,
yeah.
yes.
Then you're stuck with it. So this only applies to changes made after January 1st. Now, if they had made that change after January 1st, you could have still done what you were doing before. So the cutoff date was January 1st. So yeah, they can get away, in your case, they can get away with that because they made the change prior to the end of last year. All right? A couple more things. Small claims is now $10,000. It used to be $7,500. This means there's more cases for Judge Judy. Remember, if your buyer and seller, if they have a dispute under $10,000, they don't go to mediation, you don't go to arbitration, you go to small claims. The arbitration paragraph only applies if the dispute is more than small claims court. And small claims has gone from $7,500 to $10,000. Unless the plaintiff is a corporation, it's still $5,000. Or, if you've already sued in small claims court twice in 1 year for over $2,500, the third and the fourth time, however many times you do it, can only be $2,500 or less. You can't do more than 2 over $2,500 per year. Okay? There's a change on the listing form. Let me ask you a question. Let's say you have a listing, right? And while you have a listing, you get an offer from a buyer, right? And while that offer is pending, you get a phone call from another agent in a different office. And they say, hey, listing agent, do you have any other offers yet on this listing? Do you have to tell them? No. Can you tell them if you want to?
Yeah.
If you have the seller's permission. Well, the listing contract now gives you permission. So the C.A.R. listing form says when you're a listing agent, the seller, by signing the listing, they've given you permission to tell the second agent about the first offer. Now, I'm not saying it's a good idea. You know better than me. You're in the business of selling real estate. I'm not. But maybe sometimes you want to, if they ask you the question, do you have any other offers, you might want to say, Maybe. Maybe not. You know? Make it mysterious. Or you say, yeah, I do have an offer. And they say, how much is it? You say, it's really good. How good is it? It's really good. You know what I mean? In other words, that might be the best approach. But my point is, the listing now gives you permission to say specifically, as a matter of fact, I do have another offer, and it's for exactly $373,000. And you can even give them the name of the buyer and the name of the buyer's agent. You could take a video of the offer, put it on YouTube, and tell the entire world, anyone on the planet who has access to the internet can see that offer. You're allowed to shop an offer anywhere. I bet you didn't know that. Well, I bet the buyers don't know that. Do you think a buyer knows that when they submit an offer, the seller can take their offer and broadcast it worldwide? I bet they don't know that.
No.
Well, do you have to tell the buyer that? You already did. You know why? On the agency form, the form DA, which you better all be giving your buyers, it's referred to in paragraph 2B of the contract. On that form, it tells the buyer that their offers are not confidential. So a buyer can never come back to you and say, my realtor didn't tell me that my offer wasn't confidential. Well, yeah, you gave me the agency form. You should have read it. That's what it says. Well, what about the buyer who says, wait a second. It's the buyer who actually reads this form, right? Which is not very many. And they say, are you telling me that when I submit an offer, they can take my offer and tell anybody about it? I said, that's exactly what I'm telling you. The buyer says, well, I don't like that. I don't want to make an offer unless it's confidential. I don't want them shopping my offer. I want my offer to be confidential between me and the seller. That's okay. There's a way to do that. We have a form for that. It's called the Confidentiality and Non-Disclosure Form, CND. But you would have to get that form signed by the seller before you submit the offer. If you just attach it to the offer, they could just take that form, throw it in the trash can, take your offer, and shop it to the world. So you understand how this all works?
Yeah, the buyer doesn't really have any
What
say
liability
so.
do you have to another agent if you don't tell them the truth when they ask you if you have an offer?
Very good question. What liability do you have another agent if you don't tell them the truth? In other words, you actually do have another offer and you say no. Or you actually don't have another offer and you say yes. This is lying. This is fraud. You can get sued. You can go to jail. This is serious. You cannot lie to each other. Do not lie to other agents. That you can lose your license. You can get thrown out of the board of realtors. It's even now, it can be a criminal offense. Now, when I said you can say maybe, that's not lying. I'm saying, you're really saying I'm not going to tell you. I'm just saying I'm not really going to tell you. Maybe I do, maybe I don't. And that's okay to say maybe.
It is customary in this industry, some listing agents are checking the box multiple counter offer when in reality it is not.
That's another fraud claim that's going to lose your license. You can't do that. I mean, when you get a counter offer, you send a normal counter offer. If they sign it, send it back, you have a deal. But if you get two offers, you want to counter both of them, which one, well, the first one back wins. But you don't want to turn it into a race. You want to check the multiple counteroffer box. You're saying to each one, you're not the only one. Sign it and send it back. But even if you're the first one back, you don't necessarily get it. I still get to choose. But some agents, they only get one offer and they counter the one, but they check the box and they say it's a multiple.
Right.
You just lied to them. You told them you were countering more than one, but you weren't. That's fraud.
How do you prove it?
Can you request proof?
That's the next question. Can you request proof? Well, you can request till you're blue in the face. And they don't give it. Well, can you demand proof? No. But the problem is the only way you can actually get the proof is if you sue them. Let's say you're convinced they're lying. You file a complaint for fraud. Then they would have to prove that they had actually had the other offer. So, I mean, it's hard to prove But when you do sue them, then you can subpoena their records, and they have to prove it, or else they're in trouble. It's very difficult, but so much of this is going on, and I know you're aware of this. I mean, there's all sorts of terrible things going on now. Like the worst thing is, you have offers, you submit them, and you don't get a response. I'm sorry, I better go slow. You get no response at all, and then the property sells for less money than your buyer offered. And what a coincidence, the listing agent and the selling agent are the same person. Gee, I wonder what happened there. They deliberately didn't tell the seller about your offer because they had their own offer. So because of their greed, because they wanted to double-end it, they screwed their own client. They screwed your client. They screwed you. Just so they could get more money. This is rampant. And when you see this happening, you file a complaint. File a complaint. I mean, it's hard to prove, I know, but at least file a complaint. Say, because here's the other thing. When you're a buyer's agent, there are two MLS rules you need to be aware of. When you submit an offer, and then you fax an offer, you email an offer to the listing agent. Then you call them up on the phone. Hey, did you get my offer? You leave a message. You send them an email. You just want acknowledgement that they received your offer. If you do not get that response, some MLSs is 24 hours, some is 48. Do you know what it is here? Either 24 or 48 hours. If the listing agent does not respond to your simple request to acknowledge that they got the offer, you can go directly to the seller. Tell the seller that you have an offer, and I don't know what happened to your listing agent, but they haven't told me you got it. I just want you to know that there's an offer. That's rule number one. Rule number two is more important. Rule number two says, if you're the buyer's agent, you have the right to be physically present when your offer is presented. So you submit an offer, you don't hear anything, you call the listing agent and says, well, when do I get to present my offer to your seller? The listing agent says, oh no, I took care of that for you. I said, you weren't allowed to do that. The only time you can present an offer without the buyer's agent is if the seller, in writing, says, I would prefer that my agent present it without the selling agent. So you can put pressure on the listing agent and say, you got to do the right thing. I'm allowed to be there when you present my offer. You have to present my offer, number one. You have to present it as soon as I give it to you. And number two, I'm actually allowed to be present when you present it, unless your seller doesn't want that. So maybe they're going to be really dishonest and forge the seller's name. Now I'll call the police and have them arrested for forgery. You know, I know it's hard to enforce this stuff, but it's really rampant going on, and you really need to try to get people to stop doing it. And remember I said that DRE has more power now? Good. Good, right. There are a lot of lawyers out there who would love to sue you too, so not me, I'm on your side, but I mean, yes.
Right now, I think I see this more with REO agents.
Right.
And you can't present it to the asset manager.
Right. You don't even know who they are.
Right.
Right.
But then again, can you address the asset manager if you find out what bank it is and then ask them if they received your offer?
If the listing agent won't verify to you that they actually received your offer. I think the problem is sometimes they tell you they've got your offer, but then they don't present it.
Yeah.
Unfortunately, you're not allowed to go directly to the seller to see if the offer is presented. You go to the agent and say, how come I wasn't there when the offer was presented? I mean, you try to catch them in a lie or something. It's hard. I know it's hard to prove. It's hard to do that. And if you actually sue them, then you can subpoena them, and then they have to prove that they presented your offer. But yeah, I know it does happen a lot in REO sales. I've seen.
What about when the REO agent is using unlicensed agents to do all the work?
Turn them in for that.
Yeah, and then
report that to the DRE.
Yeah, and then you find out that then they put their name on it though. Yeah.
I know. It's hard to prove. It's always hard to prove things, but you file complaints, you follow up. If it actually goes for the DRE, will investigate them and make them prove that the person doing the work actually had a license. The DRE has more power to punish people for using unlicensed people to do licensed work too.
And they're using their MLS, Supra.
Yeah, I mean, another thing, people, they don't become members. They screw all of you who are legitimate members, by letting non-members use their MLS, by letting non-members use their Zip Forms account. That's just raising the cost for all of you good people who actually join and pay your dues. You got to turn these people in. Turn them into the MLS, turn them into the Board of Realtors, turn them into the DRE. Fraud is rampant right now. And if you don't turn them in, it's just going to keep going. You know, it's a real pain, yeah.
So what's the statute of limitations after a sale if you suspect fraud?
In general, to go after someone for fraud, the statute of limitations is 3 years from the date you had reason to be aware of the fraud. So it's not necessarily 3 years from closing. By the way, the statute of limitations to sue a realtor, not for fraud, just for making a mistake. You make an honest mistake every now and then, right? You're not perfect. How long can you get sued for an honest mistake? 2 years after close. So people call me up sometimes and say, I really screwed up. How long do I have to worry about it? And I say, 2 years you got to worry about it. After 2 years you can sleep relaxed. Okay? They can't do anything. But if you lie and commit fraud, it could be a lot longer than 2 years. It's 3 years from the date of discovery of the fraud. So I hate to end on such a downer, but I mean, we just hear it all day long on the hotline. Realtors complaining about other people in the business. It's bad enough to have problems with the banks and your clients, but you got to live with that. You shouldn't have to live with your own fellow agents, you know, taking advantage and doing the wrong thing. I mean, it's a tough business. It's a very tough business. We understand that, but you know, we just have seen more complaints than ever before. Yeah.
Landlord-tenant question. If you have multiple applications from tenants, do you have to get back to each other, or can you just keep taking them, and what, all of a sudden you finally have somebody you really like and you take them? Yeah,
landlord, you keep taking applicants so you find one you like, then you take them. Do you have to go back to the rest of them and tell them why they didn't get it? No, unless it was credit-based. If you reject, I mean, let's say you're looking for a credit score of whatever. You're going to take the first tenant you get with a credit score above 800, whatever it is. Well, now you're using credit as your basis. So anyone you reject because they didn't have that basis, you do have to go back to them and tell them you were denied for credit purposes. There's a form for that. But if you just say, it's just in general, no, you don't have any obligation to go back to each tenant and tell them they were rejected. I'm just saying, what if one of those tenants just comes out of the blue and sues you? Says, why didn't I get, then you better have an answer. And the answer would be they didn't meet the criteria you were looking for. So it's not that you have to tell them, but just be prepared to defend yourself if they come back and say, how come you didn't pick me? As long as you have an answer, you're okay. You know?
A broker license can manage property with, you don't need a separate license for.
Right, same license to manage property.
How about a sales license can manage property?
Salesperson can only property manage through a broker. You have to be doing it through the broker. You can't do it on your own. I'm not talking about being like a superintendent who just fixes the repairs and cuts the grass. That's that type of manager. You don't need a license. But a manager who collects rent and signs leases, that type of property manager has to be a broker or an agent working for a broker. First lady behind you. Yeah.
I want to know that the 21-day rule of return to deposit, if person doesn't return it within 21 days, of course, this landlord did not his or her rights.
Right.
But then after that, if this person just hiding the head, I think I'm right, I'm not getting the money back. I have a client like that right now. And I was telling her that there's going to be a penalty on top of that. And I forgot a California penalty. Is there a penalty?
You're right. In other words, when a tenant leaves, right, you have 21 days to either give them back their deposit or tell them why you're not giving them back their deposit. So landlord could say, I need that money to fix the damage that they did or whatever, or they owe me back rent or something like that. So as long as you tell them within 21 days why you're keeping their deposit, you're okay. But the problem is if you don't do anything, if you don't tell them in writing why you're keeping their deposit, You can get penalized after 21 days.
How much?
I wish I had it memorized, but it's like 2 months' rent. It's like a lot. I think it's 2 plus $300 or something like that. It's like almost 3 times the rent itself, just because you were late telling them. So as a landlord, make sure. The problem is sometimes as a landlord, you don't know what the damages are by the 21 days, because maybe they left early from a lease, right? They left 4 months early from a lease, and you haven't re-rented it yet. If it takes you 4 months to re-rent it, they owe you 4 months rent. But at the end of 21 days, you don't know yet how long it's going to be before you re-rent it. Well, then you got to take out 1 month's rent, give them the rest back, and if it turns out it takes you another 2 months to rent it, you could then go back and sue them for 2 months' rent if you wanted to. But you can't take out more than in anticipation of, I think they're going to owe me more money. You know what I mean? You following that? Yeah.
We all know that we have problems, like when we submit the offers, like so-called multiple, like fake multiple offers,
Right,
when
right,
we
right.
submit the offers, the listing agents always say, oh, the seller will not reply to you, even when we request in writing to
Right.
submit the offer.
Right.
So as a realtor, we're facing a lot of challenges, because it seems like the listing agent control a lot of things, you know. Is a C.A.R. can design some kinds of forms, even without complaint, it's no use, you know, for years and years. Can you guys design some forms that make sure that the listing
When you say you
agent-
guys, you are you guys. We just work for you. You guys can do whatever you want. You
So
guys can come up with any
C.A.R.
forms you want.
help us, you know, because we're facing a challenge.
But you are C.A.R. Talk to your state directors. Say you want a form, you want a whatever. You are a state director. We work for you. We'll do whatever you tell us to do. But, you know, it's not for us to do as staff.
So what happened is, when we request a listing agent, okay, we want to present in person, he said, oh, the seller didn't want to entertain.
Right. You say, show me that in writing.
Yes, and then it's on no time, you know, and we complain to the broker, we complain to the
File a
agent.
complaint at the Board of Realtors.
So go to the board.
File a complaint at the MLS.
DRE.
File a lawsuit.
But nothing
Well, that's not our problem if nothing happens when you file complaints at the local board. That's you guys. You got to enforce your own rules. You know what I mean? We don't enforce. C.A.R. doesn't. You got to enforce it.
What happens when the tenant leaves without a forwarding address, owing money, damage to the property?
Tenant leaves, you got to track them down. Hire a private detective. Hire Jim Rockford. He'll come and get it.
Gov, you said that the seller can't go after the bank can't go after a short seller for deficiency.
Right.
In order to allow the short sale, can he require a promissory note?
No, you can't even ask for it. Like I said, you can't even ask the seller to contribute anything now or later. Like I said, they don't have to approve the short sale, but they can't say, we'll approve it if you do this. They can't even say that. They can't even ask the seller to contribute or sign a promissory note.
On short-term rentals, do you still have to give them 21 days?
Short-term rentals, you have to give 21 days. Define short-term.
Week, 2 weeks, 3 weeks, month?
Yeah, you're right. At some point, very short-term rentals, the rules are different. I don't have it memorized. Call me, call the hotline. You're right. At some point, very short-term, so-called vacation rentals, the same rules don't apply. But I don't have it memorized. I used to know that, my mind is gone. Some of you have experienced that too, right? Yes.
I have two questions. One is, can I limit the swimming pool usage only to the residents?
I didn't hear that.
Ah, very good question. You have an apartment building with a swimming pool, and you want to say only can be used by the residents. Sure, you can do that. Yes, you can use the
I
pool.
got sanctioned on that.
By who?
Can I tell any time, like
Discrimination board.
Well, they're saying it was not based on the race, religion, or something. I mean, you can discriminate against guests.
No.
Yes, you can.
They told me we had to discriminate against everything. I had to list everybody that we want to discriminate. I can't just say guests. We had to send our manager.
I don't know what law they were citing for that, because I don't know any law that would prohibit
I
you
had to
from...
send my manager to a course.
Yeah.
We had to do all kinds of things.
I know for a fact the homeowner association can say, this is the residence pool, this is the guest pool. I don't know why a landlord can't do the same thing.
We got sanctioned.
But if you were sanctioned, I'd like to know what law they were using to sanction you, because I don't read the law that way, yeah.
I read
clarify one issue about these leases. When they're asking for like cleaning fee,
Right.
deposit,
Right.
unlawful.
You can ask for cleaning fee, pet deposit, whatever, but the total amount of deposit cannot be more than 2 months' rent. You can't have a 2-month deposit plus a cleaning fee plus a pet deposit. You can call it whatever you want, but the maximum is 2 months. If it's furnished, 3 months. And if you're going to charge one person a cleaning deposit, you got to charge everybody a cleaning deposit. You got to be consistent, right? I think we're almost done here. Yes.
Okay. If I know owner is landlord is very terrible personality, and if I have a listing, and if I find a tenant, do I have to disclose landlord did not return security deposit?
If you have a tenant you're representing trying to find a rental agreement and you know they're contemplating renting in a place with a bad landlord, yes, you got to tell the tenant, you don't really want to live here. This is a bad landlord. They don't give money back. Yes, your fiduciary duty to your client, yes, you definitely have to do that.
When tenant tries to sue the landlord because he didn't return the deposit, and if I represent the both parties for this lease, and tenant asks me to be witness at the small claims court,
Don't do it. If you're representing both sides, don't go to court on favor of one of them against the other. Because then the other one's going to say, you breach your fiduciary duty against me. If you're representing both, stay out of the dispute. Be neutral. Be completely neutral. Yes? Last question, then I'll let you go.
The deposit?
Yeah.
If they owe more than the deposit,
Right.
you actually have to write them a letter.
You still got to say, I'm taking your entire deposit. And then you can still sue them for more money later, if you want to. You're not limited to their deposit when a tenant leaves. I mean, they owe you whatever they owe you. But you got to tell them within 21 days about the deposit. Thanks for coming. I'll see you all next time. Bye.